way, you need to start back with getting people to reinstitute the covenants that expired, then decide if they want a mandatory HOA, and then elect the board of directors. Because we're skipping a lot of steps here, because the covenants were filed in '85, they expired in '05, not to mention the fact Fudger knocked all of them out except three, but they expired in '05. 20 years for anything filed before '90.
All right, we'll let Mr.
So if we're
Matthews
gonna go, we
address
gotta
this.
stop and start from the beginning to establish if all residents wanna institute the covenants. Because covenants only apply to people that agree to them.
Okay. We'll let Mr. Matthews address those. Thank you.
Well, first thing I'd like to do is pass this around. If you will sign this with your per homeowner.
Yes.
Yes, that's, you know, so we have, excuse me, so we have a record of who the homeowners are here.
We pass those around?
Yeah, it's coming down.
Did you say people who don't believe there's a home?
Lydia had people signing something, and she was asking them to read it if she agreed it. If you agreed to it, that says that I, don't believe that there's a homeowners association or ever have been.
There isn't, Jim, there never has been, and you know that.
But Jack, you were on the board and you actually paid the bills for it and
There
everything.
was a homeowners association, and you know that, Matt. You know that as sure as you're sitting there, that it was always volunteer, it's never been
All right, let's do
anything
this.
but-
Let's do this. Let Jim go through. Jim's been working on the legal side of it.
He can talk all he wants, there's no such entity.
I'd love to have an opportunity.
You know that, you both know that.
Okay, it's time for him to talk, and then you, believe me, you can say everything you want to say, everything.
I've already said what I was.
Well, the bottom line is, the notice of the meeting said it was for the purpose of electing a board of directors. Anything outside of that is outside the scope of your special meeting and is illegitimate and illegal.
Well, we disagree with that.
What's the law?
Well, I don't believe that it is the law.
Well,
And
it
so
is
if you're
the
an
law.
attorney, we
I
don't
am
believe
an
it.
attorney, and you know that. I'm his second son and his partner.
Well, that's-
And all I do is real estate law, and I know Michael Roan very well, and I've got some documents in here that had you provided him, his opinion would be significantly different.
Well,
I've
then I
got the
guess.
smoking
then-
gun that he's talking about, the fact that they hid
Well,
homeowners association from the general populace because they knew nobody'd vote for it. The covenants are expired. The bottom line is, the stuff he's talking about implied servitudes, there's no Georgia case that's ever held that. We do not live in Massachusetts. We do not live in New York. We do not live in Missouri. None of this is legally enforceable, and I can tell you that no matter what happens here today, if you file a lien against these two people's house, I'm the one you're gonna deal with, and you're not gonna like the way it turns out for you.
well, thank you very much for your opinion.
Because I've got the law on my side, I've got the facts on my side, and I've got the cases on my side.
Well, what we attempted to do, if you'll give me an opportunity to speak,
Absolutely.
what we attempted to do in this packet of information that was sent around to everybody was outline the history of our understanding of the homeowners association, what constituted its generation, and basically, in a nutshell, the original developers had, as part of their information and part of the legal status of the development, that there was a homeowners association. They were administrating it. They never did that. And at the time that about 10 of us sued the developer because they were trying to come in and take phase 2 and remaining lots in phase 1 and break them into quarter-acre lots and make a bunch of money off of it. About 10 people or thereabouts, and some of them are still sitting in this room now, sued them to keep them from destroying the neighborhood that we all bought into. At that time, the judge rendered an opinion that everything that the document stated about covenants and restrictions were thrown out, except the things that protected the homeowners. And those were in this packet right here. They were land use, covenants and restrictions, and that sort of thing. And they're very simple. And there's nothing particularly about that. Because the developer had not, he just left the field because he was irritated that that we sued him, and he didn't pay the taxes. He didn't keep up the common properties. He didn't do any of the responsibilities. So we took it on the basis of Judge Fudger's ruling that, that we now would just start the homeowners association based on the fact that the judge said, at one point he said in there, that there was, appeared never to have been one that was elected because it was administered by the developer, and he never turned it over to the homeowners. But yet the covenants and restrictions exist, and to my knowledge, they still exist in perpetuality.
Absolutely not.
Well, that's a difference.
Anything prior to 1990 has a 20-year limit.
That's a difference of opinion at this point.
Well, you want to hear the statutes, you want to hear the cases.
No, I don't want to hear the statutes. I like
It's
to.
plain, it's the law.
Let
They
Jim-
didn't change it till 93 to
please
provide
let-
for
please
automatic
let-
extension.
Please let Jim finish talking.
Well, he's spreading
Well,
misinformation.
he's got 10 more minutes, and I promise
Okay.
you, I'll give you an opportunity. Let him finish, and then
we-
we'll take every question that everybody has, okay?
Everybody has a copy of this. The people that were homeowners at that time formed a homeowners association and developed and had a meeting about 2 years between the time that the, well, a year and a half between the time that the case was held, and formed a homeowners association. Had a large meeting at the electric company over here, and at that time, it was agreed in the meeting that the homeowners association would not be mandatory in terms of dues, but there was a homeowners association, but it just wouldn't be mandatory in terms of paying dues and assessments. Now, there has been that homeowners association on a voluntary basis for the last 25 years, and there's people sitting in this room that are vocal that there isn't one, that were on the board of directors, also were making decisions associated with collecting dues and everything else. So it is our opinion that there always has been a homeowners association. Now, we took the time to have attorneys look at that and say, should we do that? Make it mandatory? Could we do that? And those opinions was, yes, we could. Our goal is not to force down anything down anybody's throats. What we've been trying to do is to say, look, we've got electrical bills that have to be paid, to keep the lights on in the front. We've got taxes that have to be paid on the lakes. We have maintenance on the lakes that have to be done to keep it from filling up with grass. We have landscaping that has to be done on the front. And we have insurance that protects every one of us. Those are just basic things that we've asked for. It's about $180 a year is what we've been asking for. Now, 25 people out of 94 people that live in this, only 25 have bellied up to the bar and paid, those fees that work in all of our common interests. It is simply not fair for me or you to have to pay for anybody else's maintenance on this. It's just not fair, because it has to be done. Because if we don't pay insurance on it, the school bus runs off into the lake, who are they going to sue? They're going to sue what they believe was a homeowners association, just like Singletary sued us, because he
We sued Carrington Lakes Incorporated, which was never the authorized homeowners association. You do not have any documentation where the members got together and voted that in.
Are you going to allow him to finish talking?
He's
Absolutely.
still got 2 minutes.
Okay.
Okay, our belief, our goal here was to say, look, there's certain things that have to be done in order to keep the place looking nice and to keep it up and to keep insurance and taxes and all that stuff done. For 25 years, there's been a voluntary group of people, consisting of 10 or so people on a rotating basis, sitting all through this room. People have been on the board and have taken responsibility to do work for other people. Now, all we really are trying to accomplish here is to say, look, let's agree that we need a homeowners association. Let's agree that we should have one. let's agree that we'll pay, to do the basic maintenance and the things that have to be done on that. Put the lawsuit aside. That's not even clarified at this point in time. There's not even a final ruling on that. To elect, a president, a treasurer, and a board of directors to have you represented. Now, if that doesn't happen, then it's just going to simply go away. And when it goes away, then the responsibility for all of those things will just go away with it, unless somebody stands up to take responsibility to do these things. I don't think anybody in here would, well, maybe you do object to paying $180 a year to have these things done for you, but that's the primary goal here. We're not trying to cram down anybody's neck. If you agree there is a homeowners association, or if you agree there isn't, do you agree there should be one? And do you agree that, that these things should be paid for?
Mr. Matthews, that's your time, sir.
Thank you.
You wanted to say something? Go ahead.
I don't even know where to begin, but I'd like to read your legal opinion. As a result of Judge Fudger's order in 1990, there are no longer any express written covenants requiring owners to pay assessments for the upkeep of the common property and the operation of the association. Your notice for the meeting said we're electing board of directors
Well,
and officers.
Wait, let him
We
finish, Mr.
have
Matthews.
to follow Robert's Rules of Orders, and we have to follow the legitimacy of the meeting. If an entity calls a meeting, that's a special meeting, it's limited to what you called it for. You called it to elect something that has no basis. You've got to start over. Now, your question is, should you have one? That's a valid question. But what you have to do is get everybody in the subdivision to have a meeting as to whether or not you institute new covenants. Your covenants are gone. The judge's order says they're gone. They
Judge's
expired
order?
after 20 years.
Wait.
They're gone. Now,
Why would you shake your head at state law? State
Wait
law
one second.
says-
Are you done?
Well-
Sorry, are you finished speaking?
but there's several issues at hand regarding this, but, I mean, you want to categorize it the way you want it. You want a homeowner association, and I understand that. That's human nature. But you can't ignore what really happened and what really exists. The law says, prior to 1993, the code says, anything filed expires 20 years. They were filed in 1985. In 2005, you no longer had those 2 or 3 covenants that Fudger left. So there's nothing you can do. You cannot assess mandatory dues. You do not have a mandatory association. Now, Carrington Lakes Incorporated was never incorporated after a membership vote of the subdivision. Will you acknowledge that? Several homeowners got together and decided they needed to go get them because Steve Simpson wasn't paying taxes for numerous years. And if they didn't go by the lakes, they were scared they'd be auctioned off and somebody else would have them. Is that not true?
I really don't know that, because I wasn't involved in it at that time.
What year did Steve Simpson die?
The person.
I think the gentleman over here had something. Do you have something, sir?
No, I'm done.
I mean, ultimately here, we've got to stick to what you called the meeting for, and the meeting's called for something that's not valid right now. You've jumped ahead. You've got to establish
We got
whether
a
or
gentleman
not.
back here who's
Well,
Go ahead.
one other thing before, I just want one last thing said, you can let him talk, however long you want to let him talk, but your assessments of $185 a year, it looks like special assessment's gonna be $4,596.77. If we count in your legal fees of $350,000 plus the judgment to Singleton of $77,500,
All right, we're gonna
That'll be
address that.
discussed during the lawsuit discussion.
All right,
which is not in your notice.
Not on.
How you doing? My name's Dave Starks. I sent out one of those letters the other day. Basically, what the law states, you want to establish a homeowners association after one has been established or is not in an existing neighborhood. After the first property is sold, you have, you guys can go start a homeowners association today if you want. That's fine. You can do it. You can get 5 members, whatever you want to do. You can file it, but every person in here would have to sign off to be governed by it. You can't go in and establish something after something's already been sold. That's definitely the law.
We can't be retroactive from things that happened before.
Sure, yeah.
To the new normal.
And I understand why they went after that property. I mean, if it's gonna go for sale on the courthouse steps, a couple of things I didn't understand. Everyone was saying, well, the county will take it over, they'll drain the lakes. Well, the county isn't gonna drain the lakes. That's number one. Here's 3 questions. One, who fixed the upper lake when the flood came through? Was it the homeowners association or was it the county? When the lower lake had its damages, who fixed that? Okay, when the fence went bad at the rail right there, who fixed that? Okay, so I understand your point as far as the legal obligation for everyone in the room for having the common ground in the neighborhood, but it's no point to establish an HOA. I mean, I understand that Carrington Lakes, Inc. is a private entity where the members of that or who started it are bound to it. But outside of that, there's no legal ramifications for anybody else in the room. Unless you guys know something I don't.
All right, so we're hearing everybody.
I'm sorry. Are you finished, sir?
Yep, I'm finished, thank you.
All right, we're hearing everybody throwing up all the roadblocks, not hearing any solutions. Every one of us in this room knows that our property values in our community are gonna be tied to the condition of the front entrance.
Before you get started, are you starting on legal status or are you just talking as a?
I'm following up on the legal status. So all we keep hearing is all the roadblocks, and you know what? They may be legitimate roadblocks, but here's the story. We're either all in this together or we're all done with it. But the bottom line is even if we were to lose ownership and it was going to go to Singletary or go to the county, whoever, and we quit taking care of the front entrance, we turn the lights off, the dam grows up to be 10 feet high, what's that going to do to every person in this room? It's going to affect your property taxes. Your property value. Even if it only affects them by 10%, we just had the latest house in our neighborhood just sold for $230,000. That's $22,000 worth of equity if our neighborhood looks like crap and we lose 10% of our value. Now, who's up for losing 10% of your home equity?
You have no basis to make a comment like that, Matt. You have
No, we do, because we've had, our neighbor across the street, who unfortunately is not here right now, when that lake was empty because of the flood in 2009, she had an appraisal done, and her appraisal took a $100,000 hit because that lake was empty at the time the appraisal was done. So there is, in conjunction with that, there's some points brought up talking about the legality of the HOA. Well, there were two closings in our neighborhood last year where I was contacted by either the homeowner or the real estate agent, where the closing attorneys found that Carrington Lakes had a mandatory HOA. And that's not the first time that we had inquiries on that. Now, hold on, because I'm going to tell you this right now. I bought my house in December 1999, which never came up at the closing table.
No.
So I'm telling you right now, everything that you've been hearing over the course of the last 25 years has been all over the board. We know that there's been closing attorneys that have found that it's a mandatory HOA. I got it in writing right here from two closings last year. But I can tell you right now, my closing never said it was a mandatory HOA.
Why isn't it registered with the state?
It is registered with the state.
No, it's not.
Go to the Secretary of State's office and it's out there. I personally have registered it there for the last 3 years.
just the corporation you're talking about, not a homeowners association, Matt.
Okay, so at the end of the day, whose advantage, who does it serve to not have an HOA where everybody in the neighborhood? Okay.
The bottom line is, the entire neighborhood may decide to incorporate an HOA that is got the full force and effect of every homeowner in there. But until you do that, everything else is illegitimate. You do not have the power. Your own attorney says, does not have the right to levy assessments. No longer any express written covenants requiring owners to pay assessments for the upkeep. So that's when he has to start getting into equitable servitudes that are out of Massachusetts and New York.
And now, you got dues and then assessments. I'm kind of scared of
Which
this.
paragraph?
Dues and assessments are
It's a-
all part of this.
Because-
Page 3, Michael Rome, implied covenants. As a result of Judge Fudger's order in 1990, there are no longer any express written covenants requiring owners to pay assessments for the upkeep of the common property and the operations of the association. That's your attorney's legal opinion.
And that was also at the time that we had in 1994, the.
Now, that's May
homeowner-
24th, 2017 is his opinion.
No, I'm saying that when we had a homeowners association, that we had elected people for it, this document that was sent out here, it was agreed at that meeting that it would not be mandatory, that the
Well, in
dues.
fact, they said we can't use the term homeowners association because nobody will go for it. Because you had to get everybody to sign off on it, because Judge Fudger tore out your covenants.
No, he didn't.
Yeah, he did. All he did is to keep the use covenants, and they expired in '05. I mean, we can discuss law till the cows come home. I've got the code and the case on my side, and all you've got is what you want. Now, you may want a homeowners association, and if everybody in the neighborhood decides that's what they want, and you want to vote in covenants, go for it. I'm not saying anybody can't do it. I'm just saying, as we sit here today, there are no binding covenants on this subdivision. There are no legal authorities for you to assess liens, dues, special assessments, or anything else. And any attempt at doing so, well, you need to ask your attorney what slander of title means, because that'll be the cause of action.
Can I ask you a question just as an attorney? Say we do.
Well, in all fairness, I just answered his open question, so I think it's probably
Okay.
back to his
Is
at time.
it
but-
okay for me to ask you? Okay. My question is that suppose we do agree to a homeowners association, all right, and this lawsuit comes up, wouldn't that be an assessment? They would have added an assessment
If you agree to an
onto it?
association, you're gonna have to incorporate an actual homeowners association based on covenants you've agreed to, which would then have the proper name of Carrington Lakes Homeowners Association, Inc.
But I'm talking about that assessment.
Right now, you
that
don't,
assessment,
that homeowners
legal.
association does not own those lakes and did not get a judgment against it.
Dave, you have something?
You know, the last 3 years, 2.5 years that this has been going on, we went a couple of years with no board of directors. I ended up being the last man standing because everybody that was on the board had resigned over a period of time. We went without a board. That obviously meant that the voluntary dues were not being collected, bills were not being paid. We got it started back up in October of 2014. That was also around the same time that some things started happening with Singletary's Dam. His attorney sent a letter to the HOA in June of 2015 requesting that we lower the lake. So I spent June, July, and into August working with his attorney to set up the getting the lake lowered. I need to back up because prior to...
One second real quick. You said you or the homeowners association?
I did because at the time I was the only man standing as a representative of Carrington Lakes Incorporated.
But not duly elected.
As far as I know, there's never been duly elected board in this neighborhood. I've been in
Since
here.
1993.
Yeah. You know, those of us that have served on the board, I know Mr. Hallmark served at one time, Jack Ray served at one time, Mike Riley.
Yeah, but we were all elected.
He never
by
signed,
homeowners.
I
he
was
never
never-
served as a homeowner's director.
Yeah, you-
Nobody ever elected him, he never agreed to take the position.
I've been here 19 years.
You have to
Wait, let's don't, we
We have the
can,
minutes
we
of the
can,
meeting where that happened.
we need to leave that where it is, we'll let him finish, and then we'll have some time for bounce backs.
So anyways, Gary Singletary had approached me one time in late 2014, I believe it was, or 13. It was 2013, regarding the standpipe in the lake that the county and FEMA had rebuilt on the Lock Highland Dam because of the failure, and said that he had some issues with his dam and he needed to get that worked on. And I said, the HOA, the Carrington Lakes Incorporated, had nothing to do with any of that engineering. You need to talk to the county. So I gave him the name of the contact at the county. He talked to the county, coordinated with the county, and we put the county agreed to put a 3-foot slotted valve in there to be able to fluctuate the level of the water for Gary to do what he needed to do. That was between Gary and the county. The only part that the HOA/Carrington Lakes Incorporated played in that is once the county did that, it was up to Carrington Lakes to regulate the level of the water based on Gary's needs to do his work. So we get into 2015, and we're ready to start working with Gary and working with his attorney to agree to lower the level so that he could do his work. So I was on the phone with his attorney. I said, we're ready to go. One of the homeowners on the lake's got his boat. He's ready to open the valve. All we need to do from you guys is a length of time that you're going to need the lake lowered so that we can let the lakefront homeowners know, what that time frame is going to be. And the attorney at that point said, no, you don't understand. We're looking to get that thing permanently reduced 3 to 5 feet. Well, I mean, there's no way we could agree to that. That's not justifiable to the lakefront homeowners there, as well as it's not justifiable to the homeowners in Carrington Lakes that have access to use that lake and use it for leisure fishing and boating. So that's how this thing ended up as a lawsuit, because they were looking for a permanent injunction to permanently lower that lake and impact the lakefront homeowners in the entire community. The lawsuit got delivered to my house. I then went to the Hallmarks. I talked to Al Hallmark, showed him the lawsuit that Carrington Lakes Incorporated was getting sued, and he, fortunately for us, presented the suit to some other attorneys that he knew and got us some reference, and that's how we ended up with Carvalho and Associates as our attorneys. I can tell you this, the suit obviously did not go either the way Singletary thought it was going to or we thought it was going to. We met with the attorney. Jim and I had to do multiple depositions because of our involvement with Singletary, both him as his neighbor and me as working with him with regards to the standpipe and discussion with his attorney. Our attorney led us to believe all along that we had a rock-solid case. He didn't guarantee a win, but he said we had a rock-solid case on multiple occasions, advised us that we had this thing, we were in an excellent position to win this thing. Unfortunately, it didn't go that way. After going through all of the negotiations, we did a mediation where Gary would not compromise at all. We ended up going to trial, and as it turns out, the Carrington Lakes Incorporation lake was indeed trespassing into the pipe that existed on Gary Singletary's property. And it had been in that water had been in that pipe trespassing since it was built in 1985. 1 month or 1 century, if the water's been trespassing, it's trespass. And so whether we like it or not, it's sickening what happened. Whether we like it or not, though, it ended up being a draw. Gary was found to be negligent in his maintenance of his dam and his property, and we were found to be guilty of trespass. We being Carrington Lakes Incorporated. Therefore, the jury did a split decision, and the estimate to replace Gary's dam presented in trial was $155,000. So the jury took that $155,000, split it in half, put half the burden on Gary and half the burden on Carrington Lakes Incorporated. In conjunction with that, we had countersued for all of the silt that came from Gary's dam and lake and impounded into the Carrington Lakes Lake. And our estimates that the attorney's engineering expert came up with is that it would be roughly $32,000 to remove that silt from impounding in our lake. So the jury awarded half of that to us from Gary. Now, the one thing that the jury did not settle was the permanent injunction that Gary and his attorney were looking for the permanent reduction of that lake. That was not in the legal confines for the jury to rule on that. That will be a judge to rule on that, and that is still in negotiations. The final negotiation that we're trying to work out with Gary with regards to Carrington Lakes Incorporated is we will, what's the word I want to say? We will forego the $16,000 payment from him in exchange for him elevating the flow-through pipe on the dam replacement, elevating it by 3 feet. That elevation by 3 feet will allow him to rebuild his dam, and it will allow the Carrington Lakes, Lock Highland Lake, to remain at full pool for the long term. The other thing that we've put in the final agreement is that there would be no money paid to Gary until such time as the dam is being replaced. We've put on the negotiating table that we would pay a third of the completion of the dam, a third at 2/3, and a third at final inspection. Okay. The reason we're taking that approach is there's several neighbors and homeowners that feel like it's questionable whether or not that dam will ever get replaced on his property. So we want to make sure that Carrington Lakes Incorporated is not writing checks to Mr. Singletary and then the dam never gets replaced.
Since it became obvious that his dam was going to crash and break, and then in the process of the suit. But I can say that there were 2 send-out requests for all homeowners to attend meetings, one in the cul-de-sac, one in his driveway. We sent out numerous update status reports of several of what the circumstances were, and at the time that we were asking not only for legal donations, of which there was approximately $80,000 donated to pay, to help pay for the attorney's fees, which we had a cap on, or at least we had an understanding that wouldn't exceed $150,000, which the other attorneys was. We had meetings, and at that point in time, when all of these letters went out to collect dues, when these letters went out, to when I called them letters, they were mailbox stuffers, to have meetings on the status of the legal situations with all the people that were involved in that and contributing money to it, as well as contributing just homeowners' dues that were asked for. Never was it ever brought up at any one of those meetings that there wasn't a homeowners association, that we weren't acting in the best interest of representing Carrington Lake. Not one person ever raised their arm.
Hold on one second.
Well, I seem to recall you attending, being on the board. I seem to recall you being on the board, you and your wife.
Said that we had no legal responsibility to pay anything.
It's always been volunteer. It's always been volunteer.
So we had no legal responsibility.
I just remember you being at the board meetings and your wife being a board member, taking all.
What happened to the cap of 150?
That's one of the things we're going to be negotiating with the attorney.
But shouldn't you do that before you come to this meeting?
Well,
we don't even know.
we're still in the process of getting the final injunction taken care of.
So the legal fees are still advancing, what you're saying?
Not materially at this point. Last month they sent me a bill for $730. So at this stage of the game, it's kind of in a holding pattern because we've put our last best offer on the table, and it's in Singletary's court. So
In terms of the legal fees to Calavano Associates, we feel we were underrepresented significantly by him. The fact that we were being sued for trespass, and he felt like he had a really good chance of winning it on negligence on the other person's part. If any of you were at the trial, at the end of the opposing attorney's summation, opposing attorney said, basically, not to paraphrase, that it doesn't matter whether trespass is a year old, 10 years old, 30 years old, or 100 years old. This, both our attorney and our expert witnesses proved that the water had always been there in that pipe. And his attorney proved that it had always been there in the pipe. And our attorney never once told us what the law was regarding that. If that had been the case, if we had been advised as to what the law was, we wouldn't have pursued the bloody case. We would have tried to negotiate some sort of agreement.
Jim, we got a gentleman over here. I love your shirt.
Color too. We're all here and we're talking about a whole bunch of different things, but the question I have is, would we be here now if the insurance was paid for before this lawsuit?
Yes.
Probably, yes.
So the answer is yes, right? Second question, why did we pay double for our lawyer compared to the other?
Well, that's a darn good question, and one that, what we understood from our attorneys was that, that the first thing that happened is they attempted to have a rule nisi, whatever that means, and to get it thrown out at a first hearing, and they spent some money doing that, and the judge said no. Secondly, they came back and said they're going to have they want to have a hearing to have it thrown out on what was the...
I can't remember the term. It was some other legal proceeding.
Some other legal proceedings and
Summary judgment.
yeah,
Yes,
summary
that's it.
judgment, and the attorney said, and the judge said no. Then they wanted to get, say, well, we much paid up. We had collected $80,000, we owed about 90, and that's where it stood. The last 6 months, of the trial, when the attorney who had been handling the case totally for Cavallo left, she quit. So he was suddenly new into the process. Between that last 6 months, they rung up more fees than occurred in the whole thing. If you had been to the trial, the opposing attorney in reviewing, because they have to review each other's fees for the opposing attorney said, well, did you notice that you have double billed for this and double billed for this, and you've got 6 months of something in here and everything? Oh, that's just a mistake. My wife did it and everything. I mean, it was just a bad situation. Now, and also at this time, he's ringing up 18% interest against this. Now, so there's maybe $20,000 owed to him in interest. And he said he'd forgo that if he got paid the other. I suggested to him, since the other attorney's fees was roughly $175,000, he ought to be willing to settle for that. He went ballistic, and he said, and I said, well, we're in a corporation. We don't know. It's doubtful that you can place liens on people's property because this whole thing was done against Carrington Lakes Incorporated. That doesn't even if you went bankrupt the corporation as it exists today, as we understand it on a preliminary basis, you still probably owe the legal fees, and you still probably owe Singletary.
I just have one question on that. Is, when did you think, like the gentleman in the back was saying, obviously you saw the numbers going up, up, and up. Why wouldn't you bring it to us and say, guys, we're in trouble. Here's our options.
Well, we thought we did that in the meetings that we had.
And to Jim's point, when we coming into 2017, we were basically current. The majority of all of those fees occurred. Well, actually, 140,000 of it occurred in, when was the trial? July? In June and July. 70,000 for the week of the trial, and then he had $70,000 worth of work that he billed in June. So we didn't even know about the 70,000 because we hadn't gotten a bill until we got to the trial.
I think we owe him money. I honestly do, but I don't think we owe him, what he's asking, and I think it would probably be,
But he knew you were not elected.
Yeah,
And
everything
there's
that
no
we're talking
capacity
about.
to bind the corporation, so now you're down to a quantum merit argument. So whatever he thinks his attorney's fees are fair market value based on the service provided.
So,
Now-
let me-
and
Let
by
me
the
ask
way,
you
he knew it was
this.
voluntary too. He
So-
knew that we didn't have any money.
When
Let me
Let
ask
me-
you
let me
this,
back
you
up.
also said in the negotiations, you told him he couldn't lien you?
No. What he said, what I asked him is, we were under the assumption that, that the court would award the property to Singletary if we default on paying him, since, that was our assumption.
I'm talking
And-
about the attorney's fees. What you said was you told him that it's not like he could lien you
No,
because
no.
you're a corporation.
What we asked him was, is he going to put a lien, I asked him, is he going to put a lien on properties to try to get his attorney fee?
He being Singletary or
No,
he
he
being?
being
attorney?
Carvalho.
Okay.
And he said, I don't know that that's possible because it's a corporation. And I don't want to get to that stage. I want to work out how we get paid.
Well, I don't know why the attorney would have told you that, because if you owe me money, I can lien you, and if I lien you, if it is in fact a mandatory HOA, I get a charging order from the court, and then I assess all the homeowners, which he can't do that, but that's the process, so any attorney should know that's as simple as
Well, he knew.
filing it and proceeding
Yeah,
with
he
it.
knew it was a voluntary organization. He knew that, that all dues and assessments and everything was voluntary. He knew that we didn't have, the kind of money that he was, that he eventually rung up on the thing, and we made a best effort at collecting from about 25 people, monies to keep the thing going before he went berserk on it. So I honestly can't tell you. Now, one of the other things that I guess is next on the table is, should we bankrupt the corporation and just call it a day?
I got one
Because
more
I
question.
don't want anybody to have to pay, legally we owe Singletary. It's really gone.
Legally, Carrington Lakes Incorporated owes Singletary.
Okay, Carrington Lakes owes Singletary. I believe that in all honesty, we owe Calavano, additional fees, at least equal to what his attorneys put up, but,
Well, I've got one last question, and I'll let somebody else take on. You agree liens are off the table?
We don't know,
Well, now you just said you weren't gonna lien because you couldn't lien.
well,
So if you can't lien, why did you hire a management association? Because all they do are slap liens and sue people. That is all a management
The
association
management
does.
company that we hired, the contract was strictly to do the finances for the community, which would be send out the letters, collect the checks, pay the bills, publish an annual report, and that's it.
So your
Keep us
contract had
registered.
no authority to lien anybody that didn't
They
pay.
didn't, we did not even
Yes,
provide
they
them a
do.
copy of our
They do.
covenants, and they didn't have the authority to lien.
So their letter didn't threaten the lien.
No, that was not part of the contract. We hired them strictly for one reason, and that was for them to do all the financials so that we take the burden of doing this entire job off of the homeowners in the community. Because I'm done. I'm done. I got my resignation letter typed up and ready to go. And if you guys want to let the HOA go and let the dam grow up and turn the lights off at the entrance and let the whole entrance.
whether or not it's a mandatory, voluntary, or non-existing, HOA or whatever you want to call it, you've got Singletary's court decree that money is owed him. You've got the potential for some attorney fees issues, and you have to decide whether or not you want to have some entity that will pay the taxes, pay the insurance, pay the lights, and maintain the lakes and maintain the grounds around there. If you don't want to do anything about it, it's easy. We'll either bankrupt bankrupted, or just let the license expire, and that's that. So what you have to walk out of this meeting is, and say, do we want Singletary to own those lakes and take our chances on what he does with them? Do you want to have some voluntary neighborhood association, you know, not homeowners, neighborhood association that says we've got some real simple things here, pay the taxes, pay the lights, that sort of stuff, and contribute to it? Because right now, over the last years, only 24 or 25 people out of 94 have ever bellied up to the bar and paid that stuff.
So if,
And that's not fair.
if he does drain the lake or take the lake over, does that take away some of our legal fees, some of the legal fees?
No.
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 Okay, and when we do, and if we should, because the bottom line is we have to vote whether we want an HOA or not. So if we do an HOA, and that's the maintenance, yes, but will that leave us open to have our property slammed with this $4,000 assessment? That's what I'm talking about. That's the bottom line. That's why you're asking for the HOA now, because of this, right? Because of this, or does the HOA fees collectively help to pay that legally?
No. No,
So
the fee,
then there's gonna have to be a separate assessment.
you got three things. You got pay Singletary or not. We don't even know that he's gonna do his lakes, okay? So pay him or not, that's still hanging up there because there isn't a final judgment set down. The second thing is, can this attorney, based on this being a voluntary, you know, HOA at this point, by everyone's belief system here, we didn't think so. We got some legal opinions that said not, but let's assume it is just a voluntary and it's not legal. Does Calavano have a right to lien individual property? That's a question mark. And that has to do with whether or not you bankrupt the existing entity or just let it dispose itself. And then the third is, do you want to have a neighborhood association that somehow bellies up to the bar and pays the common things that we should all be contributing to? So those are your basic four things.
We're gonna walk away from this, you know, are we going to pursue some other entity? You know, and what are our options? I don't know about you guys, I don't wanna incur any more legal fees for sure. So,
Well, in all
according,
fairness, you haven't incurred any legal fees. Carrington Lakes Incorporated has, and the only way they can get it out of the homeowners is if they can establish a mandatory HOA.
See?
They cannot establish that. The covenants expired in 2005. Theoretically, your attorney can't even collect because you didn't have authority to hire him. So he's looking at quantum merit at best.
can you explain that to us?
Quantum merit basically means if I do a job and we don't have an agreement, you owe me what's the fair market value for it. I'll give you an example. We had a case where a helicopter flew a kid out from a car wreck to a hospital. They charged $180,000. Well, he was unconscious. He didn't sign a contract. Under quantum merit, we got that reduced down to 28. Still high, but a lot less than what they wanted. You can't just charge anything unless you put it in a contract and have people bind it. As a volunteer, I mean, don't get me wrong, you've done the best you could, but you did it without legitimacy. Corporations have to vote on their officers. If you don't, in fact, there's case law at the Wazoo that says if you don't have elected directors and officers, you can't even issue mandatory dues when there is a mandatory HOA. So the bottom line is there are routes that you can go to minimize this, but the individual homeowners, if there's not a mandatory HOA, which there's not, the legal opinions may say you might prevail, but it all starts bringing in laws from other states because we do not have a case in point. It's going to be an uphill battle. You're going to the Supreme Court, and then you're going to hope that they decide to be just like Massachusetts or just like New York.
Which nobody ever paid for,
Exactly.
period.
So how do we fix this?
So the bottom line
Yeah, of course,
is,
good.
the way it is nobody has individual liability for this right now. Carrington Lakes Incorporated has a judgment for $77,500 against it. The attorney has not sued you yet, so you don't have a judgment.
In
for
your
that.
legal opinion, should Carrington Lakes
I'm not gonna give a
incorporating-
legal opinion for Carrington Lakes, because I'm here by proxy for the Hallmark, so I don't, that's conflict of interest.
So-
But what I'm telling you is, I'm not concerned for them at all about having to pay anything, and if anybody liens their property, the attorney or anybody else, I'll handle it.
Could I ask
But-
you a question here?
Well, I mean, ask them,
Okay.
you own the house, you just have to. I mean, I got a proxy, so I can speak
I
for you,
just
but.
want to know that if some of us voluntarily want to help out with those expenses, that's not outside the realm here. But to be made to do it by the threat of a lien or something on our house is a totally different thing. So I just want to know, we're not obligating ourselves if we voluntarily.
No, you can establish a voluntary association. You as, I mean, let's be honest.
No, I mean with the fees for that log or whatever they
Well,
owe.
you don't want to join, well, even if you
Okay,
join
I'm
that,
just
you're not
asking.
bound because it's a nonprofit. I mean, there was a legal opinion written in '93 that basically outlined there's two ways to hold these lakes. One is a nonprofit, one is the voted upon homeowners association. What I'm telling you is they chose the first
The nonprofit.
because that attorney gave the advice, I forget the gentleman's name, but he's still around. It wasn't Bud, but it was,
Marvin Johnson?
Marvin,
yes.
yeah.
That attorney gave the advice, you want to hold it in a nonprofit as opposed to the HOA, because if a child, now, at that time, it wasn't about the dam, but they said attractive nuisance. If a child drowns in the nonprofit, they cannot lien the individual homeowners. If you have a mandatory HOA, they can.
And that's why we've been carrying insurance.
And that's the genesis, though, of this. You are not a mandatory, you cannot lien people. They can't collect this judgment. All they can do is take the lake.
So if the insurance goes away, just hypothetically, insurance goes away and a kid drowns in the lake, what recourse,
They can sue Carrington Lakes Incorporated and take whatever asset it may have, which is
which is
the
the lake?
lakes and the downspout.
And any
Which
property that's
apparently
listed on the
did.
Carrington.
So if we establish.
I'm sorry?
a
Any
legal-
property that's listed on the Carrington Lakes.
Exactly, anything it owns. I mean, if somebody were to donate a car to Carrington Lakes, they could take that, but.
So if we established a legal HOA, not saying we own them, they would be able to.
If somebody drowns, and here's the thing, I don't know what kind of insurance you're talking about, but I'll be
No,
honest
no, I
with
wanna
you, if
know
I
about
got
the
a,
legal fees.
if I got a
would they be able to
25-year-old that's in
assess
med
us
school
then?
and he's studying neurology,
Yeah.
I can get over your insurance and still come after you.
Would they still be able to, if we did, say we voted on an HOA, would those legal fees then be assessed to us?
No.
No.
Because if you
It's
vote on a
after.
mandatory now, you're gonna have to reestablish covenants.
Yeah,
Then you gotta vote on a mandatory HOA, then you're gonna have to install officers, and that's going to be a separate entity for what owns the lakes. Now, the problem is, you don't own the lakes as your mandatory.
Does it have to be
My question
complete?
What if
Everybody
you
has
don't
to
wanna be
vote
the
on it?
HOA, do you,
Yes.
I mean, if you
You'd have to have
that
approval.
choice to say,
One-
no, I
If
don't.
you don't
Approved
sign off,
for the
you're not
whole-
part of the HOA.
all-
Favoring of meeting again in January.
Well, first you gotta move,
A vote?
then you need a second.
Second? Who would like an HOA? Who would like not to have an HOA? Majority? Okay, we're good.
second.
What are these guys to do? Just throw this in the trash can over here and walk away? Is that what, I mean, these guys been working on this for some time.
Look, the only thing
What do
that,
you want them to
look,
do?
it's not just us two, it's you, it's him, it's a number of other people that have been involved in this for the last 2 years. The only thing remaining to be done is for somebody to show up, not our attorney, because we're not gonna pay him to go to the courthouse to stand there and see what the summary judgment is that the judge delivers, that, to it is. That's the only thing left for at least one person to show up in that, and somebody will do that. We're not gonna pay an attorney to do it, okay? So we're finished, and you guys now have it in your pocket, to decide when you wanna meet, how you wanna handle, this, and by that time, and I'm told that the judge is gonna make that happen as far as Singletary is concerned within the next 2 weeks. I think there's already a court date set on it. So ultimately, the only decision you have to make is, how do you want to organize your neighborhood association? What dues do you want to try to collect to maintain the stuff that we've laid out right here? And whether or not you want to see the lakes go into Singletary's ownership. And as far as what this other attorney could do, we don't know. He says there's no basis to lien property. So that's about it.
Well,
Do
in
we
all
wanna meet again
fairness,
in January?
just so you know the process, just because he gets a judgment doesn't mean he gets the lakes. He then has the sheriff come attach it, and they sell it, so guess what? We can all go bid on it.
So, say that one more time.
You don't just get something. When you get a judgment, trust me, I got a whole desk full of judgments I'll never get.
Exactly.
When you get a judgment, it's a piece of paper that says you're entitled. You then go through the procedure of foreclosing that judgment, and you have the sheriff seize the property and auction it at a sheriff's sale.
Well, we were told he would just simply own it.
Now, unless you sign it over.
What about if you,
The board of directors no longer exists.
I was gonna say, what about